A legal challenge could shake up Florida's race for governor. Lieutenant Governor Jay Collins, who is running for governor, is suing to remove fellow Republican candidate James Fishback from the ballot, claiming that he does not meet Florida's constitutional 7-year residency requirement, something Fishback disputes. Christina Burgess is here now breaking down that lawsuit and what it could mean for this race.
Yeah, Heather, Lieutenant Governor Jay Collins says that public records show James Fishback registered to vote and voted in Washington, D.C., purchased property, signed mortgage documents, and received a D.C. homestead deduction. Fishback disputes the claims, calling the lawsuit a political attempt to keep voters from choosing him. I took a closer look at the complaint and spoke with the political analyst who says the timing of this case could be critical.
This complaint is about relevancy both for Fishback as well as for Collins. They're both in the low single digits in this race.
A new legal battle is taking shape in Florida's Republican primary for governor. Lieutenant Governor Jay Collins filed a lawsuit challenging the eligibility of fellow Republican candidate James Fishback. The complaint argues Fishback does not meet the Florida Constitution's requirement that a candidate for governor must have resided in the state for the 7 years leading up to any election, including the primary this August. The suit names Florida Secretary of State Cord Byrd as the defendant in his role as the state's filing officer, with Fishback listed as the real party in interest. According to the complaint, Fishback registered to vote in Washington, D.C. in November of 2020 and listed a D.C. apartment as his residence. The lawsuit also claims Fishback remained an active registered voter in D.C. as recently as of June of this year. Collins' campaign also points to public records it says shows Fishback purchased property in Washington, signed mortgage documents identifying it as his primary residence, and received a D.C. homestead deduction. The lawsuit says this means Fishback cannot satisfy Florida's 7-year residency requirement and that he submitted a false candidate oath when he qualified for the race. Collins is asking the court to expedite the case, remove Fishback from the ballot, or at least require that voters be notified that votes casted for him would not count if he is found ineligible. But Fishback is pushing back. First Coast News reached out to Fishback. He referred us to his statement posted to social media on Monday. In it, he says this is a, quote, desperate attempt to illegally remove my name from the ballot and block Floridians from voting for me. His statement goes on to say, quote, because I own a small apartment in Washington, D.C., where my sister currently stays, nothing in the Florida Constitution disqualifies a candidate for governor because they own property in another state. Jay Collins knows this. He doesn't care. He knows we are headed for a historic victory on August 18th, and he is trying anything he can to stop us. It won't work, end quote. First Coast News political analyst John Daigle says this isn't the first time questions have been raised about Fishback's residency. He says the court may have to move quickly with the Republican primary set for less than 2 months.
The timing is really important here. It's an August 18th primary. If they're going to be mailing ballots in mid-July, those ballots probably have to be close to being printed now. I don't know exactly how quickly the courts would have to decide this.
And Collins argues that he has the legal right to challenge Fishback's qualifications because they are both candidates in the same race. A judge has not yet scheduled a hearing on this case. We reached out to the Lieutenant Governor Collins' office for an interview or comment and have not heard back at this time.